où cette question de business et de droits humains est bien sûr extrêmement importante dans le développement des relations entre ce pays et l'Union européenne. Par ailleurs, notre sous-commission a préparé un avis sur le paquet dit Omnibus 1, à savoir la révision de la législation adoptée, le mandat passé sur le devoir de vigilance des entreprises. Nous avions bien pris en note de la déclaration de votre groupe de travail sur le sujet qui encourageait l'Union européenne à veiller à ce que toute évolution relative à cette législation soit conforme aux principes directeurs des Nations Unies relatifs aux entreprises et aux droits de l'homme. Notre avis a été adopté en juillet et Jury, la commission en charge du rapport, votera son projet de rapport le 13 octobre prochain. C'est un sujet complexe, très débattu et votre présence parmi nous tombe donc à point nommé. Vous avez, cher monsieur, la parole pour 8 minutes.
Merci, Monsieur Sartori. In September 2012, 260 people died and 36 were injured during a fire in a textile factory in Pakistan due to negligence. I'm sorry my example is not Rana Plaza in Bangladesh, where you've just been. Those who died were mainly women, and some may have been children, and some may have been persons with disabilities. A major German retailing company was the main customer of this factory. The retailer had clear internal guidance about factories in terms of health and safety. They did not do a specific test of this factory. They did not check about pollution from it or the type of workers. These are all human rights abuses for which a European company contributed to or was directly linked to. In this instance, the German company did have a part settlement of the claim and gave some compensation. However, under the changes proposed by the Omnibus, not one person whose human rights was adversely impacted or damaged in this real-life example might have been able to bring a successful action against the retailer. The same could apply for instances of human rights abuses, environmental or climate change damage in many, many sectors, in mining, construction, transportation, a whole range of sectors across Europe under the proposed Omnibus. Now, why do I say that? For 3 reasons. First, there may be no human rights abuses in Tier 1. In many instances, a European company, its first supplier will be within that same state, excuse me, might be in another European state or might be in a state, as in this instance, which its first tier was in a state where there were no human rights abuses. It was down the supply chain that the real risk, the real human rights abuses occurred. And there's also the risk that the actual consequences, such as to this particular company, are only discovered later. And so the investor in the company, the shareholders, the consumers are not aware of the real risk to the company. It could also harm small and medium-sized enterprises, the proposed changes, because if they're in Tier 1, they may be deluged with a whole range of administrative burden when the real risk lies elsewhere. As a consequence, companies domiciled in the EU or operating in the EU are likely to miss real adverse human rights impacts across their whole value chain as they're only looking myopically at the Tier 1 suppliers. Secondly, if the plausible information that is needed under the proposed omnibus means that the German company in this instance itself had to have specific information about the specific issue in the specific factory, then there would have been no plausible information in this instance. They didn't check, so how would they know? So there may be the problem that there is no evidence of that plausible information. In this particular instance, there was social media information. Civil society did a deep dive to find out the evidence, and that puts huge demands in resource terms on civil society and rights holders. And if plausible information is interpreted in this narrow way, it would not have required the German company or any EU company in a similar position to ask any questions. It would also mean the company would not act on human rights abuses based on their severity, but based simply on plausible information, which is inefficient and complicated. Third, The lack of any harmonised civil liability across the EU, as proposed by the Omnibus, would mean that it's up to each court to make its own decisions. And very often it's a small provincial court, which is where the company is based, which is meant to make these decisions on matters of which they've got no experience, which has real harm to the rights holders, but it also could make the company possibly facing claims in different jurisdictions for different outcomes. So what does a working group propose? As the Chair has explained, we're an independent body of experts. We're the only independent UN body with a mandate about corporate responsibility for human rights. And so our role is here to alert the subcommittee to the deep concerns which it has, and it's made public statements about this, that the proposed omnibus departs from consistency with the normative standard in this area. So what do we propose? Firstly, that the final provision needs to be consistent with the UN guiding principles. This requires, for example, a risk-based approach to adverse human rights and environmental impacts, not one based on a particular tier or plausibility of information. Instead, it requires effective human rights due diligence and, where appropriate, remediation by business. Second, access to effective remedies for those right holders who are affected. And this is a remedy to the rights holder, not just a fine to the business. Third, it should include the value chain of a business, not just its supply chain. Why? Because as the European Central Bank of all institutions had said, it should apply to financial institutions in their funding. And we also see that with the sale of weapons, for example, in conflict zones such as Ukraine. It should also include human rights impacts of climate change as part of human rights due diligence, as a number of recent international courts have said. So what ways do we suggest? Well, the starting point must be, in accordance with EU law, that there needs to be good evidence base. And I was part of a deep research which was part of an impact assessment requested prior to the Corporate Sustainability Due Diligence Directive, which we undertook and which found of 650 businesses we engaged with, which is a lot of work, the significant majority of businesses, up to 80%, wanted a single harmonised EU law consistent with international global norms. Why? They wanted legal certainty, clarity, coherence, and to assist them in their value chain. We also found, although there are some costs to businesses, in the end the opportunities were greater. And it also showed there were no distortions in either intra-EU or external EU competition. And there's been no evidence of that provided in relation to the omnibus. And that I also note the very recent Norwegian experience in their non-paper, which shows that businesses, including small and medium-sized enterprises, approve a risk-based human rights due diligence approach with broad scope in terms of businesses and human rights included. Second, look at the practices, the actual practices of companies. There were companies such as, just to pick two examples, Mercedes, Aldi Süd, where they look at the actual risk to them, not just at their first-tier suppliers. This respects human rights and is good business practice. It also means that blanket questionnaires sent out are not needed. You've focused questionnaires to those the suppliers, to those who you're selling to, where there are real risks because of the issue or the location. It also means a company has the incentive then to work down their supply chain with SMEs to improve practices long term. Third, to ensure that the omnibus proposals are consistent with the UN guiding principles, the OECD guidelines and other global norms, so the smart mix of measures proposed under the UN guiding principles is implemented, that businesses have certainty and that victims have a remedy. This would mean the final proposal based on the omnibus then becomes consistent with the three pillars of the UN guiding principles: the state duty to protect human rights, the corporate responsibility to respect human rights, and access to effective remedies. So what would I ask of the European Parliament? Firstly, that it should push back against these omnibus proposals to make sure they are consistent with the UN guiding principles, consistent with business practice, consistent with the reality of what's happening in this area. Doing so would address the real concerns I've highlighted today, which would both assist rights holders and would assist companies, and would enhance simplification and competitiveness, which the previous reports and surveys have already shown. And secondly, pushing back would also mean that those affected by the actions of businesses operating in the EU, whether causing, contributing to, or directly linked to adverse human rights impacts, including those killed and injured in the factory fire in Pakistan, including those killed and injured in Rana Plaza, where you've just been in Bangladesh, they have an effective access to remedy. Thank you.
Merci pour ces propos. Je voudrais excuser notre rapporteur sur le dossier, Barry Andrews, qui a un imprévu et ne peut pas être parmi nous aujourd'hui. Et en son absence, j'aimerais vous rappeler les points essentiels de notre avis sur l'Omnibus 1. Nous saluons dans cet avis la démarche de la nouvelle proposition de la Commission européenne qui vise à simplifier et à alléger la charge pesant sur les entreprises de l'Union européenne. Cependant, cet objectif ne saurait remettre en cause les responsabilités de l'UE en matière de défense des droits humains et de protection des défenseurs des droits. La législation adoptée dans ce domaine le mandat passé donnait à l'Union européenne la possibilité de s'affirmer en tant que puissance normative mondiale et avait permis de tisser une cohérence et une complémentarité entre les politiques, créant ainsi un ensemble solide avec ces directives qui font aujourd'hui l'objet d'une révision. Par conséquent, un réexamen pourrait remettre en péril cette approche dans un contexte mondial où les normes relatives aux droits humains sont de plus en plus remises en question. À cette fin, notre avis propose de garder les éléments suivants. Veiller à ce que la définition des parties prenantes reste suffisamment large afin de s'assurer que toutes les voix concernées soient entendues aux différentes étapes de la procédure de vigilance. Veiller à ce que les entreprises ne restreignent pas leurs mesures de vigilance à leurs partenaires commerciaux directs, mais les adaptent en fonction du risque d'incidence négative déterminé par leur secteur d'activité et le contexte de leur activité. Demander aux entreprises d'entretenir un véritable dialogue avec les parties prenantes pour éclairer et améliorer leurs décisions et leurs pratiques en matière de vigilance, mais aussi pour assurer la protection et la sécurité de l'ensemble des parties prenantes contre d'éventuelles mesures de riposte ou de représailles liées à leur participation. Enfin, exiger des États membres qu'ils prévoient la possibilité pour les entreprises de suspendre une relation commerciale pendant une période déterminée. Voilà l'avis que notre sous-commission sur la responsabilité de Barry Andrews a rendu à la commission en charge du dossier sur le fond. L'heure du débat avec les députés présents vient d'arriver. Bonjour, Monsieur Assis. Cher Francisco, tu as la parole.
Merci beaucoup, Monsieur le Président. J'irai, comme d'habitude, parler en portugais, ma langue. Mr. Robert McCorkdale, I think is correct his pronunciation. Queria começar por saudar a sua intervenção, bastante interessante e que colocou os pontos fundamentais deste tema. Noutros tempos, a responsabilidade pelos abusos dos direitos humanos recaía estritamente sobre os Estados. Felizmente, hoje também recai sobre as empresas e sobre as consequências nefastas que podem ter as suas atividades nacionais e transnacionais no campo dos direitos humanos. É um novo ramo do direito, como sabemos, que está a emergir e que modifica de forma expressiva o próprio direito internacional. E a União Europeia, há que o salientar, está de novo na vanguarda da produção legislativa e na regulação da conduta das empresas. Ora, estando a fazer progressos inquestionáveis na responsabilização legal das empresas, ainda estamos, contudo, numa fase incipiente no que respeita ao cumprimento efetivo da lei e à reparação pelo sofrimento causado. Sobretudo se pensarmos que uma parte substancial das populações vítimas desses abusos por parte de empresas, sobretudo grandes empresas multinacionais, são populações de regiões isoladas, com baixos níveis de escolaridade e, por isso mesmo, já muito fragilizadas e desprotegidas. Não podemos também subestimar o papel da ONU nesta evolução, desde logo a influência exercida pelos princípios orientadores da ONU sobre direitos humanos e empresas. A questão que me pergunto e que me interrogo e que gostaria também de colocar é sobre a evolução das negociações em torno de um tratado vinculativo. Um processo que se iniciou em 2014, por isso há mais de uma década, e parece estar estagnado, com pouca participação e relativamente pouco entusiasmo, incluindo, lamentavelmente, da parte da própria União Europeia. Por isso a minha questão é muito simples, gostava de saber a sua opinião sobre esse projeto e que possibilidades se vislumbram também na sua perspectiva de prosseguir este caminho que consideramos absolutamente fundamental. E uma vez mais agradecer a sua exposição que foi bastante esclarecedora. Muito obrigado.
Merci Francisco. Catarina.
Thank you very much, Chair. I won't dare pronounce your last name, so I'll go Mr. Roberts. Thank you very much for being here, for your expertise, for your contributions, and for your role, as well as the entire UN Working Group on promoting business and human rights globally. We, of course, welcome your work and the fact that the UNGPs are there to to give clarity to companies, and then we also try, as lawmakers, to set standards that are legally binding, and in that the EU has had a wonderful opportunity to emerge as a global leader for corporate responsibility. Regrettably, as you've mentioned, the latest omnibus proposal really risks lowering these standards, narrowing the scope, and weakening the enforcement. And with this, I cannot say that I'm usually not the second person to speak on this committee. Usually I come quite at the end, but I see that the room is rather empty, and I really must remark that I'm very disappointed to not have colleagues from other political groups listening to your important remarks. So not a remark to you, but maybe to others. From our side, of course, I was shadow on the opinion of Trois, and we believe that any weakening of the CSDDD will be a mistake, and we need to hold companies accountable worldwide now more than ever. So I have a couple of questions for you. First of all, perhaps I would like to ask you, where do you see the European Union in our own journey when it comes to corporate accountability? I feel like we were very much, obviously, at the forefront. We were legislating. We were ready for implementation. In the general fight and struggle to bring about business and human rights as a concept, are we perhaps also returning to the point of agenda setting, naming and shaming companies? Do you think we need other strategies now as EU civil society, policymakers, etc.? And how are we in relation to the world? So many were following our example. We're legislating based on, maybe not based on the CSDDD, but inspired by it. Are those cases still ongoing, or is everyone looking at us, taking a step back and going, well, actually, maybe not? Secondly, I would like to ask you, obviously, in line with the UNGPs and also the OECD guidelines, it makes sense to have a horizontal law, as we had with the CSDDD. We see a huge backlash and a possible weakening. So I'm also wondering, is it time to go back at looking at human rights violations in certain sectors that are highly at risk for human rights, like agriculture, textiles, extractive industry? Should we be looking at specific legislation or policy for sectors as the EU? And finally, last but not least, it's kind of related, kind of not, but as the European Union trades, this is the big conversation of our days. How can we better integrate the concepts and the responsibility that the business and human rights agenda brings us in our trade policy and agreements? Thank you.
Merci Katharina. Avant de vous redonner la parole, peut-être deux petites questions. Je fais partie de ceux qui pensent que l'argument de la réduction de la charge ou de la simplification pour les entreprises ne devrait pas pousser l'Union européenne à ne pas prendre sa responsabilité pour la défense du droit de l'homme. Comment est-ce qu'on peut travailler ensemble? Comment il y a une direction qui est prise? Je pense, à titre personnel, qu'elle ne va pas dans le bon sens. Comment continuer à porter ce sujet? Comment continuer à convaincre? Et comment créer des coalitions, y compris avec les entreprises responsables qui souhaitent s'engager, pour garder malgré tout une dynamique et qu'une remise en question de la réglementation ne fasse pas tout s'effondrer. Ça, c'est la première question. Une deuxième question qui est complémentaire. Vous l'avez dit, et moi je le crois, le respect des droits de l'homme, ce n'est pas qu'une contrainte, ça peut aussi être des opportunités pour avoir des marchés. Vous avez cité dans votre intervention préliminaire des entreprises qui avaient des démarches positives. Comment les multiplier? Comment, face au récit de il faut faire le business, on est dans un monde concurrentiel, laissant les principes de côté, comment, à partir d'exemples concrets, à partir d'opportunités réelles, porter une mobilisation pour faire la démonstration que ça peut être gagnant-gagnant?
They are great questions from all three of you, for which I thank you, and it shows your real engagement in this issue, for which I applaud you. I'll start with Monsieur Assis's first question, which you looked, one of your parts of your question was about the binding treaty on business and human rights. That is not a responsibility of this working group. It's very confusing. There are two working groups. One's an intergovernmental working group. We're an independent expert working group. So but we nevertheless do feed into it. We give our views. We often come in to assist in clarifying some of the coherence with the UN guiding principles. And I, in my capacity prior to being on the working group, was heavily involved in the process of the creation of the treaty. In fact, literally stood between two members who might have otherwise come to fisticuffs. So that there's a lot of tensions still and very divergent views within the binding treaty. However, it almost links in with the point by Madame Vieira about what does this mean, having a binding treaty in a global sense? Because the risk is it becomes a global South treaty. There is no global North engagement, or that the EU goes one way and the treaty goes the other way. So it's actually a fabulous opportunity for the EU presence to have a real mandate to negotiate. Because what I see again and again is what I call rule of law countries, such as those within the EU, are absent from a lot of the discussion. They're not there to engage with, well, how does this actually work in practice? And so you end up getting a very diverse and not always helpful discussion. It'll take a while, and the reality is any human rights treaty takes a while. I mean, I've been involved in some of the others. Some very quickly, the Convention on the Rights of the Child, some very, very slowly, the Convention on the Rights of Persons with Disabilities. And I think here, actually, the EU could be a real catalyst for moving that forward. And my worry is that should the proposal of the Omnibus move back away from where the Corporate Sustainability Due Diligence Directive was, it'll actually reduce the possibility of a treaty, or at least a treaty which makes a difference to business and also a difference to rights holders. So it's a great question. And that fits in with your, I think, very helpful question about cutting edge. To what extent is the EU with these proposals still at the cutting edge? I've worked with a lot of governments around the world. It's one of the honours of the work I've done, and I've been working in this for 30 years. It is very much one where the EU's role in both engaging with EU companies in this area as well as those operating in the EU can be profound. And that's, if you like, it links in with Madame Vieira's question. What impact could it have by no longer being at the cutting edge? And I can speak of at least one example directly. South Korea is introducing laws on this area. Why? Because they're influenced by what the Corporate Sustainability Due Diligence has led to. And they're now thinking, well, do we want to be at the forefront of this if suddenly things are moving backwards in the EU? And I think that is a real risk. And the second risk is leading businesses. I gave two examples in the talk I gave, but there are others. They're like, we've worked on this. I mean, 2011 was when the guiding principles came into being. The best ones have been working on even before then. And they're like, well, suddenly we're going to be at a competitive disadvantage, to pick up Monsieur Satori's question. Why? Because they have hoped that this regulation would mean, instead of being undercut on their prices by, let's say, a competitor using child labour, they're like, well, suddenly this corporate sustainability due diligence directive would have brought us to the same level. Suddenly we're being undercut again without any restrictions on what they do. So there's a deep risk that the EU is no longer at the cutting edge and no longer applying the international norms, which affects other states, as I've given the example, businesses, as I've given an example, but also rights holders. One of my other things is I'm a practicing lawyer for many years, and it's very hard. If you're a rights holder, I gave the example of Pakistan. If you're a rights holder in Pakistan, and in a way, Monsieur Assis mentioned this, they don't have the knowledge or the skills to even know how to bring a claim. And somehow or other, it's not going to happen in Pakistan. It didn't happen in Bangladesh, as you've just seen. How are they going to feel there's any route forward to them? Because very often the countries in which this is happening are ones where there is no legal aid, there is no legal support, there is no ability to bring a separate claim, not least because very often the companies involved are hand in glove with the government and therefore not likely to be able to take any of these kind of actions. So I think there is a real risk that moving away from the corporate sustainability due diligence will raise the risk you indeed raise. You also raised two other questions, Madame Vieira, one of which is, are there certain sectors one should be aware of? It's interesting, in the early drafts, at least of the German Supply Chain Due Diligence Act, there were certain sectors which were flagged. And in fact, the working group has done a lot of work on what it calls heightened human rights due diligence. So if you're a business working in a conflict-affected area, let's say you're working in, or were working in, say, Syria or Democratic Republic of Congo or Ukraine or Russia in relation, you need to think, how much is your presence there affecting the human rights? Simply being present. And I can give you a specific example. A French cement company was in Syria, and this is during the period of ISIS, and they wanted to protect their operation, so they negotiated with the ISIS leadership that they would help them, move around, etc. They have then been charged successfully before the French courts for complicity in war crimes or crimes against humanity. Now, that is where there were no rules for them to follow, and that is the real risk. Now, to come back to your question, part of the issue would be, I think it's a twofold, making it for all sectors, but having a particular flagging for companies. If you've got an operation in a conflict zone, you need to do more. If you're in a particular sector where we know there are issues, as to say you've just been to Bangladesh, you can pick out the sectors pretty easily. That will actually help companies, I think, rather than harm them. So I like that suggestion. You also asked about integrating trade policy and business and human rights. I don't pretend to be an expert on trade policy. However, and comes back to Monsieur Assis's question on the treaty at the moment has a provision which says trade and investment agreements need to take account of what's in the treaty. And that could be a very powerful way to begin to integrate them. And, an example would be there was a case in Argentina about supply of water. Water used to be free to all. It then became privatised. And then what happened, of course, those in the favelas were not getting water regularly. Why? Because they weren't paying the kind of sums that the water company wanted. So they just cut them off. Where's your human right to one of our basic needs of water? Just disappeared. So then Argentina took a case against them and said, OK, you need to provide this. And the company sued Argentina in the international investment arena, saying, you've stopped our agreement. And guess who won? The company, not the protection of water. And that's the real risk of not integrating protection of human rights into trade and investment. Monsieur Sartori, you asked a really good question about decreasing burden on businesses. I can see where that simplification comes from. My worry is it's got a bit blurred with the simplification on the Corporate Sustainability Reporting Directive and the Corporate Sustainability Due Diligence Directive. And the Reporting Directive, yes, required quite a lot of demands on a company, but actually the Corporate Sustainability Due Diligence Directive, I think, assists companies. That's what I'm trying to sort of assist companies, assist rights holders in a way that the Corporate Sustainability Reporting Directive arguably was too much. And I think the two have accidentally kind of come together in a way that I think is not very helpful. And so the simplification, I think, and as I said, I've been involved in this a very long time, has not been proven in relation to the Corporate Sustainability Due Diligence Directive. Now, I've done work on this for a long time, and businesses are not saying it's too complex. In fact, the leading companies are saying, we want this. And so that's, I think, where the two have slightly got a confusion. And then how to create coalitions to work forward. Let me come back to Monsieur Sis's question on the treaty. One of the elements of the treaty provisions is on mutual cooperation with other states. And I actually think that's not a bad way of thinking on this. That if, for example, you have a European company, I don't know, extractive industry in Democratic Republic of Congo, very, very hard for that kind of engagement to happen in an effective way because the rights holders are never going to get remedy in Democratic Republic of Congo. It's in a sort of semi-conflict affected area. But actually, to capacity build the Democratic Republic of Congo, to actually help them, is a very effective way of then building them together so the European company still has the European standards, but actually you begin to lift the standards of other companies operating in the DRC, including, and I say this slightly contentiously, Chinese companies operating there because, and this comes to your last point, we can provide incentives. I sometimes think we think of this area as being all about sanctions and criticism. But actually one of the great areas, it can be an incentive in two ways. Firstly, public procurement. If a state says we require your company, before they can get the tender, to comply with basic elements of human rights due diligence, that would encourage the application of and integration more broadly of what was a Corporate Sustainability Due Diligence Directive. And secondly, it would mean a company that is happy to go into Democratic Republic of Congo and I'll use the example again, child labour, because it's a very real issue there, actually wouldn't win the contract because you, the EU, had been working with the Democratic Republic of Congo to make sure that they don't enable that to happen. And so there are ways, just to integrate your two questions, that actually assist companies and assist rights holders, but also begin to raise the game of other states, so it's not just as if everything looks like it comes from the EU. You've asked lots of great questions. Hopefully I've covered all the questions that you've had. Please come back if there's other issues that I haven't covered. Thank you.
En tout cas, merci pour ces réponses claires. Il nous reste un tout petit peu de temps. Si Francisco ou Katharina souhaitaient reprendre la parole, vous pouvez. Et bien sinon, je vais lever cette séance en vous remerciant encore pour votre présence et vos propos. La séance est levée et on reprend à midi pour le dernier point de la matinée. Donc il y a une petite pause, n'allez pas trop loin. On se retrouve à midi pour le bilan de la mission au Bangladesh, qui est une mission très intéressante. On en dira un mot tout à l'heure.